Hello and welcome to the June edition of our Employment Team podcast. We understand that the priority of most employers right now is dealing with the implications of the COVID-19 crisis as it continues to evolve. Our team of employment lawyers are advising on COVID-19 daily and are here to help. We have a dedicated hub which contains our latest insights on COVID-19 across all areas of our business. This can be accessed from our website. Despite the current challenges, we also want to keep you up to date on business as usual updates. So the first matter we are going to address in this podcast is our top 10 tips for dealing with subject access requests. Employee disputes are now almost inevitably accompanied by a subject access request, requesting significant volumes of the employee's personal data. Complying with subject access requests generally requires extensive search exercises and cross-departmental working to gather and review the data requested. Ultimately, it can prove to be hugely time-consuming without the right approach. So today, we have summarised our top 10 tips when it comes to dealing with SARS. Number 1, educate staff. The ICO's position is that any request where an individual is asking for their data should be treated as a SAR, regardless of the form the request takes. Given the timescales involved, staff need to be able to quickly identify SARs and ensure that they are actioned. It can work well to set up a designated mailbox into which SARs can quickly be channeled. Number 2, know your timescales. Typically, SARs require to be responded to within 1 month of receipt. The timescale for responding can be extended to 3 months where necessary. However, the requester should be informed of any extension as soon as possible, as well as the reasons for this. Number 3, review the scope of the request. The requester is only entitled to submit a SAR to access their own personal data. Requests for information beyond that, for example, requests for copies of company documentation or data relating to other named individuals, may be ignored. Number 4, consider whether there are grounds for refusing a SAR. There are limited circumstances where a SAR may be refused, namely where a request is manifestly excessive or is unfounded. However, we recommend taking legal advice before refusing any SAR entirely, as it is likely that the requester will make a complaint about the refusal to the ICO. Number 5, identify appropriate search parameters. Consult with your IT team about the searches required to locate the requested data. Ask the requester to specify the personal data they have a particular interest in to inform the search parameters to be used. Number 6, use technology to assist. After searches for the requested data have been carried out, consider using technological solutions such as e-discovery platforms to more efficiently review the material that has been returned from those searches. As a firm, we have partnered with software providers who have developed their own SAR-specific tools that can be used to quickly home in on the material that is most relevant to what the requester has asked. Number 7, keep exemptions in mind. UK legislation contains a number of exemptions to the information which should be provided in response to a SAR. For example, correspondence that is legally privileged. Ensure those involved in reviewing the SAR material to assess what is or is not disclosable to the requester are familiar with these exemptions. Number 8, limit the use of redaction. It is common that the material that has been requested as part of a SAR will contain mixed data, that is, personal data of both the requester and of other third parties. Rather than redact all the third-party data mentioned, the law requires that organisations should either A. Check whether the third parties mentioned consent to their data being disclosed as part of the response to the SAR, or B. Take a view as to whether it would be reasonable to disclose the mixed data material without the third party's consent. Number 9, go paperless. There is no requirement to compile a hard copy of the requested data to provide to the requester. In the event the requester insists on a paper copy being provided, a fee may be charged for that. And finally, number 10, put a subject access request action plan in place. Having a pre-prepared plan setting out the approach your organisation takes when a SAR is received can really help to streamline the process and significantly save time when responding to a SAR in practice. Our team are well placed to support you at all stages of the SAR process, from reviewing your internal SAR action plan to advising on the management of a SAR that you have received. Please just get in touch with your normal Burness Paull contact if you would like more information on how we can assist you. Next, we're going to consider some practical tips from recent case law. The first case is Duchy Farm Kennels against Steeles. In that case, Mr. Steeles brought a claim against his former employer, Duchy, in the Employment Tribunal, and the claims were settled via ACAS by use of a COT3 agreement. The terms of the COT3 provided that the settlement sums would be paid in instalments, and that the parties agreed to treat the fact and terms of the COT3 agreement as strictly confidential and not disclose them to anyone. Mr. Steeles disclosed the existence of the settlement and its amount to a third party, and Duchy ceased making the payments to Mr. Steele. Mr. Steeles sued Duchy for sums due under the agreement, and Duchy argued that the confidentiality clause was a condition of the agreement, a breach of which allowed Duchy to bring the contract to an end and cease payments. The court held that the confidentiality provision was not a condition of the agreement. Rather, it was an intermediate term, meaning that the only way Duchy could be released from its obligations under the agreement was if the breach of the confidentiality term was so serious as to amount to a repudiatory breach of the agreement. The court held that the nature of the breach was not so serious as to amount to a repudiatory breach. This case serves as a useful reminder for employers that where confidentiality is of fundamental importance to the parties, the COT3 or any other form of settlement agreement needs to be carefully drafted. Employers may consider specifying that the confidentiality term is a condition of the agreement, or make specific provision in the agreement regarding what will happen if there is a breach of the agreement. For example, repayment of all or a proportion of the settlement sums. Next, we consider the constructive dismissal case of Williams against Alderman Davies Church in Wales Primary School. Where an employer behaves in such a manner that their conduct amounts to a fundamental breach of contract, an employee may be entitled to resign in response to that conduct and claim that they have been constructively dismissed. The breach of contract does not have to be one serious act. It can be a group of trivial acts, provided that the cumulative effect is a fundamental breach. Nor does the last act of the employer need to be a breach of contract by itself, but it has to contribute in some non-minor way to the cumulative breach. It cannot be an innocuous act or omission. This is known as the last straw doctrine. In this case, Mr. Williams was a disabled teacher suspended for alleged child protection matters. Despite the fact that social services decided no further action would be taken, the disciplinary investigation continued for over a year. The employer's approach to the handling of the disciplinary was poor, and Mr. Williams complained about a number of procedural matters, but his grievance was not upheld. When the school refused to let Mr. Williams speak to a colleague and relevant witnesses, he resigned and claimed constructive dismissal. Mr. Williams argued that his employer breached the implied contractual term of trust and confidence, with the last straw being the school's failure to allow him to contact the witness. The Employment Tribunal found that the last straw was innocuous and reasonable. Therefore, Mr. Williams did not resign in response to a breach and was not constructively dismissed. On appeal, the Employment Appeal Tribunal held that as long as there has been earlier conduct which amounts to a fundamental breach, as was the case here, provided the employee has not waived the employer's earlier breach and the employee resigns at least partly in response to the earlier breach, a constructive dismissal claim can succeed. That is so even where the more recent innocuous conduct also contributed to the decision to resign. Employers should be mindful that even reasonable and innocuous acts may result in an employee resigning and successfully claiming constructive dismissal, as long as the employee has not already waived an earlier fundamental breach. Our third case involves a claim brought by various claimants against W.M. Morrison Supermarkets plc. The Supreme Court required to consider whether Morrisons were vicariously liable, the concept of one party being held liable for the acts of another, for the actions of its employee, Mr. Skelton. Mr. Skelton deliberately uploaded payroll data of Morrison's staff to a publicly accessible file-sharing website. Affected personnel raised an action against Morrisons for breach of the Data Protection Act, misuse of private information, and breach of confidence. For a vicarious liability to be established, the wrongful conduct must have been closely connected with the acts which the employee was authorised to do. The Supreme Court held that Mr. Skelton's wrongful disclosure of the data was not so closely connected with his role that it could fairly and properly be regarded as having been carried out while he was acting in the ordinary course of his employment. Although his employment gave him the opportunity, in committing the wrongful act, he was not engaged in furthering his employer's business, but was pursuing a personal vendetta. The court did express a view that an employer could be found vicariously liable for breaches which are committed by an employee who is acting as a data controller in the course of his or her employment. For example, where an employee negligently leaves confidential documents on a train. Although the employer was not liable on this occasion, this case serves as a useful reminder that employers should have clear policies specifying what an employee can and cannot do with personal data. The final part of our podcast is a roundup of issues which are currently in the news. The government has published guidance on the new statutory right to parental bereavement leave and pay, which came into force in April 2020. Despite a House of Lords committee report stating that the change to off-payroll working rules should be rethought before being extended to the private sector, the government is pressing ahead with legislation for the changes to be introduced in April 2021. And finally, in COVID-19 related news, the government published guidance on holiday entitlement and pay during coronavirus. The ICO published guidance for employers on workplace testing, and ACAS has published guidance for staff on coronavirus and mental health at work. Both the UK government and the Scottish government have published various guidance documents for employers to help staff return to work safely, and have also published guidance regarding the new contact tracing schemes. We hope you've enjoyed this edition of our podcast. Our next edition will be in August. Thank you for listening.